It's over, or at least that's what you're being told. The promise of transparency, the assurance of accountability, the declaration that everything the public demanded has finally been delivered. According to official statements, the full set of Epstein-related files has now been released. Case closed, nothing left to see. But the deeper you look, the harder it becomes to accept that narrative at face value, because buried beneath that confident announcement is a contradiction that refuses to go away. Millions of documents, previously acknowledged, previously identified as relevant, previously expected to be disclosed, are still missing from public view. Not a handful, not a minor oversight. Millions. And while officials insist they've met their legal obligations, they simultaneously admit that a substantial portion of material remains withheld, without clearly explaining how much or why. That tension is where this story really begins. On paper, the government claims compliance with the law that required the release of these records. In practice, the reality looks very different. A formal communication sent to lawmakers confirmed that obligations had been fulfilled, yet in the same breath acknowledged that certain documents were still being kept back. No precise number was offered, no detailed breakdown provided, just a vague assertion that some materials could not be disclosed. And that raises an obvious question. If everything that must be released has been released, why are there still millions of pages being withheld? To be fair, not every document should automatically be made public. There are legitimate reasons for protecting certain types of information. Materials that contain explicit abuse, deeply sensitive personal details about victims, or anything that could cause further harm to survivors absolutely deserve careful handling. No serious person disputes that. Safeguarding victims is not just reasonable. It's essential, but that explanation only accounts for a narrow category of records. What's happening here goes far beyond that. Instead, the justification being offered leans heavily on legal doctrines, technical privileges that typically allow government agencies to keep certain internal discussions and legal communications confidential. These include concepts like deliberative process privilege, attorney work product, and attorney-client confidentiality. Under normal circumstances, these protections can limit what gets disclosed in court cases or public records requests. The problem is that this situation is not normal. The law that mandated the release of these files was written in unusually broad and explicit terms. It wasn't vague. It wasn't open-ended. It clearly outlined what had to be turned over, and it did so with a level of specificity that left little room for interpretation. Entire categories of documents were named directly, including internal communications, investigative decisions, and records related to how evidence was handled. In other words, the very types of documents now being withheld are the same ones the law explicitly said must be disclosed. That contradiction didn't go unnoticed. Lawmakers who supported the legislation had already anticipated this exact scenario. Before the official response was even issued, questions were raised about whether the government might attempt to rely on these traditional privileges as a way to avoid full transparency. At the time, the expectation was clear. Those arguments wouldn't hold up because the law itself overrides them. And yet, that is precisely the route being taken. To understand why this matters, you have to look at how these legal privileges actually work. They aren't absolute shields. They're limited tools, designed for specific contexts. The deliberative process privilege, for example, is meant to protect internal discussions that occur before decisions are made, ensuring that officials can speak candidly without fear of public scrutiny. But even that protection has boundaries. It doesn't apply to factual information, and it generally loses force once a decision has been finalized. Similarly, attorney work product is intended to safeguard the mental impressions and strategies of legal professionals preparing for litigation. Attorney-client privilege protects confidential legal advice between a lawyer and their client. Both are important in the legal system, but neither was designed to override a direct mandate from Congress requiring disclosure. And that's the key point. When a law clearly states that certain records must be released, those traditional protections don't automatically apply. In this case, the legislation went even further. It didn't just list what needed to be disclosed, it also specified what could be withheld, and that list was deliberately narrow. It included sensitive victim information, materials that could interfere with active investigations, classified data, and a few other carefully defined categories. Notably absent from that list were the privileges now being cited as justification for withholding documents. That omission wasn't accidental. When lawmakers want to allow agencies to rely on those kinds of privileges, they say so explicitly. There are plenty of examples where that language exists. Here, it doesn't. So the argument being made now essentially asks everyone to believe that the law both requires disclosure of certain records and simultaneously allows those same records to be withheld under doctrines the law never mentions. That's a difficult position to defend. There's also a broader constitutional dimension to this conflict. At its core, this is a clash between branches of government, between the authority of Congress to demand information and the power of the executive branch to control its internal operations. In situations like this, the balance of power becomes critical. History provides some guidance. There have been cases where courts recognize that government privileges exist but can be overridden when there is a compelling need for disclosure. In oversight disputes, especially those involving potential misconduct, that need can be particularly strong. Transparency becomes not just a policy preference, but a constitutional necessity. One of the most significant examples comes from a past presidential scandal that ultimately reshaped the relationship between government secrecy and accountability. When efforts were made to restrict access to critical records, Congress stepped in with legislation designed to preserve and disclose those materials. The legal challenge that followed reached the highest court, which ultimately upheld Congress's authority to act. The reasoning was straightforward. When the legislative branch clearly expresses its intent, and when the executive branch has already accepted that framework, claims of absolute privilege lose their force. That precedent casts a long shadow over the current situation, because here the law was passed with overwhelming support. It wasn't a narrow or partisan measure. It moved through the legislative process with near unanimous backing, and once it reached the president's desk, it was signed into law. That act of signing carries weight. It signals acceptance of the law's terms, including its requirements and limitations, which makes the current resistance even more difficult to reconcile. If the law is as clear as it appears, and if the authority to demand these records is well established, then the question becomes not whether the documents should be released, but what happens if they aren't. There are several possible paths forward. One option is for lawmakers to demand a detailed accounting of what is being withheld. In legal proceedings, this often takes the form of a privilege log, a document that lists each withheld record along with the specific reason it is being kept secret. This allows for meaningful review and prevents agencies from hiding information behind vague or overly broad claims. The legislation in question already seems to anticipate something like this, requiring explanations for redactions and summaries of withheld materials. Whether those requirements are being fully met is another matter. Another possibility is litigation. Congress has, in the past, gone to court to enforce its oversight powers when faced with non-compliance. That route can be slow and complex, but it has produced results before, including court orders requiring the release of contested documents. There are also more aggressive tools available, though they are used less frequently. Subpoenas, contempt proceedings, and even budgetary leverage all fall within the scope of congressional authority. Each comes with its own political and practical challenges, but they remain part of the system's built-in checks and balances. Ultimately, this situation is about more than a single set of documents. It's about whether transparency laws mean what they say, whether oversight mechanisms function as intended, and whether commitments to accountability are followed through when they become inconvenient. Because it's easy to promise openness. It's much harder to deliver it when the information in question is sensitive, controversial, or potentially damaging. That's where the real test lies. And as this unfolds, one thing becomes increasingly clear. Declarations of completion don't necessarily mean the job is done. Not when key pieces are still missing, not when explanations don't fully align with the law, and not when the stakes involve understanding one of the most troubling cases in recent memory. So, while you're being told that the process is over, the reality suggests something very different. The story isn't finished. The questions haven't been answered. And the gap between what's been promised and what's been delivered remains impossible to ignore. Because in the end, transparency isn't measured by what's released. It's measured by what's still being hidden.